Hey everyone, good afternoon. Welcome to today's Lunch and Learn. We are highlighting sort of the activities of the last year that the Navajo Nation has pursued after the landmark Brackeen decision. It's a Supreme Court decision that addressed whether or not ICWA was constitutional. And of course, one of the children at issue was a Navajo child, a child eligible for Navajo enrollment. And the nation was one of the litigating tribes in the case. And we've certainly used that experience as a source of lessons learned. And I think some of you may have joined for one of our earlier ICWA presentations to show the progress we've made in the last year of really taking a more aggressive approach to protecting ICWA and more fully implementing it or utilizing the benefits of ICWA to benefit Navajo children. And of course, again, part of this is coming out of our experience in litigating the Brackeen case. And it is now almost a year later that the decision has been out there. And so we wanted to give you guys an update on all of the things that the nation has pursued over the course of the last year. And there are some very exciting things. 65% of Navajo children have been placed with Navajo families since the decision came out, and that's an increase of 11% since last year. So we're very happy about that. We've also had 100% involvement in private adoptions and guardianships of Navajo children. And we're continuing to take measures to strengthen the nation's role in these ICWA cases, particularly in the state of Arizona, where we are intervening in all of the cases where a Navajo child or a child eligible for Navajo enrollment is involved. And something that Division of Social Services and DPM through their Office of Vital Records has done in the course of the last year is amend an existing MOU, which is an agreement on how to share and transfer information relating to enrollment for ICWA eligible children. And by strengthening that agreement, and taking some other administrative measures within the various offices, we've been able to reduce the turnaround time to confirm eligibility for enrollment for Navajo children from 2 weeks to just 5 days, and in some cases, even fewer days. So we're very, very happy about that. And I'm just really proud of the programs and the attorneys at the Department of Justice who work on this issue. We actually have kind of a cross-section of attorneys at the Department of Justice that cover ICWA matters, both in our Human Services and Government unit, as well as in our litigation unit. And for those of you who don't know me, She Ethel Branch Yin Shek, Bean Patwitni Nishlin, Nakai Bashas Chin, Sitnijini Dasha Che, Ado Nakai Dashanala. And I'm going to go ahead and hand things over to our presenters. Again, we have a mix of presenters today because this is a matter that is cross-disciplinary. It takes many hands to make sure that our ICWA eligible children are taken care of. So thank you guys so much for being here with us today. I will hand things over to LaTanya Johnson, the AAG for our Human Services and Government unit.
Thank you, Attorney General Branch. Good afternoon. She'e LaTanya Johnson Ganashia, Munchkiji Nishle, Kiani Bashichi Tosanete Senhabitli Asiana. I am an Assistant Attorney General with the Navajo Nation Department of Justice, and I provide legal assistance to the Navajo Nation ICWA program and other departments within the Division of Social Services.
Thank you, LaTanya. My name is Sage Metoxen. I'm an attorney with the litigation unit at the Navajo Nation Department of Justice. I'm a member of the Wichita and affiliated tribes of Oklahoma. I'm born and raised in Oklahoma, and I went to law school and undergrad in Oklahoma before moving to the nation back in 2013. And our team works on the litigation side of the legal issues at the Navajo Nation Department of Justice.
Good afternoon, everyone. Yat is a Crescentia so Ninchia. Twodik Ocean Shloma Idish Gishni Bashashin, Ashida Shada Shanella. I'm the program manager for the Navajo Indian Child Welfare Act program.
Thank you, everyone. So we'll first start with a brief overview of the Indian Child Welfare Act. I do want to start with noting that this law is also referred to as ICWA. So throughout the presentation, we'll be referring to as ICWA. I also do want to note that this federal law, ICWA, refers to our Navajo children as Indian children. That's just a term of art that the Indian Child Welfare Act provides in the actual law. So I do want to note that for background purposes, that ICWA was passed by Congress in 1978. It was passed by Congress to ensure that our Indian children, including our Navajo children, were not removed from homes. There was a large amount of Indian and Navajo children who were removed from our families because of poverty, joblessness, and substandard housing. And as a result of many of our children being removed, Congress enacted this legislation to ensure that there are measures in place to avoid unnecessary removal of our Navajo children and other Indian children. Now, the way the ICWA works is it applies when it involves the state of a child custody proceeding. And the child custody proceeding includes foster care placement. It also includes when there's a termination of parental rights, pre-adoption, and adoption placement. It also applies when it involves an Indian child. An Indian child is defined as a child who is eligible for enrollment or who is enrolled with a respective tribe, which is why Attorney General Branch had noted it is very important that our timeline of the agreement between the ICWA program and the vital records is important to ensure that a nomination becomes involved sooner than later, so we can determine whether the child who is subject to that child custody proceeding is in fact an enrolled member of the enrolled or eligible of the Navajo Nation. It also requires the state to conduct active efforts. Active efforts, are ensuring that the state do affirmative duties to ensure that our Indian child could remain or should not, in event should not remain with the parents or guardians. So there are a number of measures in place that are outlined in ICWA that provide the best interests of our Navajo families and our Navajo children. And this is why, ICWA is very important. And when there are any type of alarms as to, challenging ICWA, such as what has happened in the Brackeen case, the nation will continue to be actively involved in any challenges against the Indian Child Welfare Act. So I will allow my colleague Sage to go over the overview of the Brackeen case in the United States Supreme Court. Sage?
Thank you, Latanya. So many of you have probably heard of this case by now. We're about to hit almost exactly a year, as Madam Attorney General said, to when this case came out. So it was filed in 2017 by a few non-Indian families and states in an effort to invalidate ICWA. So it was filed in 2017, but the decision came out just last year on June 15th. So it started when the Brackeen family filed an adoption petition in Texas District Court to adopt a 10-month-old Navajo baby boy after the little boy was removed from his Navajo mother. So the nation got involved in this case at the Fifth Circuit level. So that means when the case was being appealed, the nation intervened to make sure we were involved to protect the interests of the nation and the Navajo child. So the case eventually worked its way all the way up to the Supreme Court. And by that time, Some other cases had been consolidated in, so there were other adoptions at issue involving other Native children from other tribes and non-Native families who were trying to adopt them. Some states had also got involved, but by the time we reached the Supreme Court, it was just Texas, the only state still hanging on the case by that point. And 4 other tribes intervened as well as the nation. So there was the Cherokee Nation, Oneida Nation, Quinault Indian Nation, and Morongo Band of Mission Indians. So the Brackeen family did eventually adopt the Navajo baby boy and later his biological sister, a Navajo girl, through, even though her adoption wasn't at issue in this case, they did end up adopting both of those children. So DOJ was involved through all of those steps. We put a lot of time and work and effort into this case. And so that's what I'm going to talk about today, 1 year later. So when it got to the Supreme Court, these were the questions that were presented to the court. So basically, these are the issues that the court was deciding whenever they were looking at the case. The first one you can see up on the screen: does ICWA or do certain provisions of ICWA impermissibly commandeer the states? So this argument is basically saying that Congress is not allowed to force states or state officials to adopt or enforce federal law. So the anti-ICWA people were arguing that that's exactly what ICWA does. It's forcing the states to enact and enforce ICWA in different ways in state courts. And so they thought it was unconstitutional. Of course, the tribes pointed out ICWA is really just setting standards. It's setting procedural standards for the child custody proceedings, as well as substantive standards. And Congress is allowed to do this. There's not really a question that Congress can create rights like this, like ICWA does, and require states to enforce those rights. The second issue: does ICWA violate equal protection? So here, the anti-ICWA people were arguing that ICWA treats Indians different than other American citizens based on a racial classification. And they're arguing that that difference makes the ICWA unconstitutional. So we defended this by arguing that ICWA classifications are actually based on tribal affiliation, which are political and not racial. And this is exactly what the law says up to this point. All of the case law and other law points to the fact that tribal classifications are political because tribes are sovereign. They're political entities. The Constitution recognizes them, and they have a government-to-government relationship with the United States. So members of tribes, the people that ICWA applies to, have this political relationship with the United States. And so they're a political group for the purposes of ICWA, and it's not unconstitutional to do that in a law. The next issue: has Congress exceeded its Article I authority by enacting laws governing child custody proceedings? So this argument is basically saying that Congress doesn't have the authority under the Constitution to enact ICWA. And they were also saying that child welfare generally is a subject matter that's really up to the states to regulate, that the federal government shouldn't have a hand in regulating this issue. And that's really not true. None of the case law follows that. Up to this point, we know that kind of the opposite is true. And that's what we put forth in our arguments, but that's the argument that the anti-ICWA people were making here. The next issue: does ICWA violate the non-delegation doctrine by allowing tribes to alter the statute's placement preferences? So non-delegation means Congress can't give its legislative powers to other branches of the government or other entities. In ICWA specifically, I think this might have been touched on, and we're going to go into more detail later, but there's a provision in ICWA that says where a child should be placed if they can't be with their biological parents. And there's another section in ICWA that allows tribes to decide the correct order, basically, that those placement preferences should be in. And the anti-ICWA parties came in and argued that this is basically allowing tribes to change the legislation that Congress wrote, and that's unconstitutional because it's giving the tribes the same power as Congress. But really, this section is just incorporating tribal law, and that's a permissible action. It's not unique to ICWA, and Congress has done this in other instances. Okay, the last issue finally, do the individual families have standing to challenge ICWA's placement preferences and really just standing in general? So the tribes in the United States argued that none of the families had standing to raise an equal protection challenge, and neither did Texas. Standing is basically when a party has the right to challenge something, and they can only do that if it's directly affecting them. So the issues the parties were challenging here, none of them were actually affected by those issues. They were just arguing against these provisions of ICWA generally. So we were saying, hey, these parties don't have standing to even raise these issues in the first place. And that ended up being important to the court's decision, which I'm going to talk about next. So the decision of the court came out 1 year ago. We waited all of these years, and the decision actually ended up being a huge victory. Really, this was beyond anything we could have hoped for. When we were working on the case, everyone was very concerned. We were worried that the Supreme Court was going to come in and overturn ICWA, or at least tear ICWA apart, take out important provisions. And everyone was sort of preparing for, what are we going to do if this happens? But then the opinion actually came out, and that didn't happen. Instead, the court surprised us, and they came back and basically rejected all of the anti-ICWA arguments. So you can see on the screen here, first, the court determined that Congress does have the power to enact ICWA and other laws governing Native Americans. They said that this is well within Congress's power, and that all the law up to this point points to that conclusion. The next is the court also rejected their anti-commandeering arguments. They found that all of the provisions of ICWA were constitutional under anti-commandeering, and Congress was permitted to require states to comply with these ICWA provisions. Finally, the court declined to rule on the equal protection and non-delegation issues that I just talked about, saying that none of the parties actually had standing to bring those issues. So none of the parties were actually affected by those parts of ICWA that they were complaining about, and the court didn't touch those. So that was a victory. It means that we might see these issues raised again, especially the equal protection issue in a future case. But for now, it's a victory. ICWA has remained in place, and all of ICWA remains. It hasn't been altered or amended, and that's a huge win for everybody. I'm going to touch really quickly on the concurring opinion. Justice Gorsuch often does this, and here he wrote a beautiful concurring opinion. Justice Sotomayor and Justice Jackson joined in part to this opinion. And if you're interested in learning more about this, if you're interested in learning more about ICWA and the history of tribes in the United States government, the history of Indian child welfare, and the act specifically, this is a really good place to start. So Justice Gorsuch goes into a lot of detail on all of this history. And you can see I pulled a quote out of his opinion here. In adopting the Indian Child Welfare Act, Congress exercised that lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. I'm going to turn it back over to Latanya and Crescentia now. Thank you.
Thank you, Sage. So I do want to express my gratitude and appreciation to my colleagues in the litigation unit who were actively involved in the litigation aspect of the Brackeen case. There was a lot of effort that went into it. It started all the way into the Fifth Circuit 2 times, and then all the way to the United States Supreme Court. So I do want to highlight all the effort that the Navajo Nation Department of Justice has did to ensure that we keep the safeguards of ICWA and ensure the constitutionality of ICWA. I also do want to know, as Sage has pointed out, is there is still the outstanding issue of equal protection. And the fact that there could be a future challenge to ICWA based on the grounds of equal protection challenges. So knowing that the Navajo Nation, along with other tribes, are aware of that particular issue, and under Attorney General Branch's administration, we are making that a very a timely concern to ensure that we address any issues, and working with the ICWA program and other departments and division of social services to ensure that we address any ICWA challenges moving forward, not only the state of Arizona, but all the states in which the nation receives a notice of a child custody proceeding. So on that note, I do want to provide the next slide to Crescentia, and she'll be doing an overview of the ICWA program.
Thank you, Latanya, and thank you, Sage, for that overview. So as Sage and Latanya had provided an overview of the law and what that means and where everything is at right now, one of the things that I wanted to share on is really like how is the law implemented at this point, and what does it look like when the Navajo Indian Child Welfare Act program becomes involved. And so first and foremost, for the Navajo Nation to be aware of any child custody proceedings, we must first have notice sent to our program. So the Bureau of Indian Affairs has a federal ICWA registry where it outlines all of the identified ICWA agents across the U.S. on where notices should be sent. And so this is really important for us to make sure that all of our contact information is updated and we receive those notices in a timely manner. As soon as our program receives notice, we immediately began coordinating with the Navajo Office of Vital Records to move toward verifying whether the child or children are eligible for enrollment or they are enrolled with the Navajo Nation. Once we receive that information, we send that information back to the state agency or the private petitioner to indicate, yes, this is a Navajo child and the Navajo Nation will be involved in this case and there will be an ICWA social worker assigned. The ICWA social worker will follow the case throughout the life of the case. They will be involved in in the court hearings and the meetings that occur, in addition to providing additional support. So for an example, if there is a child that is placed in foster care, and there is a relative that's identified here on the Navajo Nation, our social workers will go out and make contact with the relatives and conduct a home study so that we can provide that information to the state indicating this is a safe home where a child can be placed, and we immediately start making those arrangements to get the child placed with a relative. On this slide, you'll see all of our currently active cases across the United States. So our program is extremely busy in being involved in all of these cases that are currently in the state courts. Next slide, please, Latanya.
Is that the slide you're referring to, Crescentia?
That's the one that we just went over.
Okay. Okay. So on this note, as noted by Crescentia, the nation would generally receive notice from the state regarding the child custody proceeding. And at that point, the Navajo Nation, as pointed out by Crescentia, is we will determine whether the child is eligible or enrolled with the Navajo Nation. And at that point, once it is determined that the child's eligible or enrolled, the Navajo Nation becomes involved. So in an effort to strengthen our ICWA program, in response to the possible equal protection challenges under ICWA, and others who could challenge ICWA, on this particular matter, the nation has hired 3 law firms in the state of Arizona. And we have done specifically state of Arizona because that's a high number of cases that we have received. And there have been other entities within the state of Arizona that have challenged ICWA in the state of Arizona. So we want to be well prepared for any challenges that happen out of the state of Arizona. And this allows our outside counsels to assist and work with our Navajo Nation social workers to ensure that we are handling these child custody proceeding in a very timely and efficient manner and consistent with ICWA. We started this project of including the outside counsel in January of 2024. And since then, we have had 43 notices from the state of Arizona, which has allowed all our outside counsel to provide assistance from. Most of the notices are from Maricopa County and Coconino County. As Sage pointed out, there has been challenges to the placement preference. And I apologize for that noise. I don't know where the noise is coming from, but I hope you all are able to hear me. So we do, as noted by Sage, there has been challenges to the placement of our Navajo children. As ICWA does require that the state place our Navajo children in the order which is noted on the slide. And the first placement is with the minor child's extended family. The second is the foster home that is tribally licensed and approved by the Navajo Nation and, of course, other Indian tribes. The third preference is the Indian foster home license and approved by authorized non-Indian foster care agencies. And the fourth is the institution approved by the Indian tribe or operated by Indian organization, which has a program suitable to meet the child's needs. I do want to indicate that it does provide for the extended family. And if the child does come from a mixed race, the child's extended family could include a non-Navajo family. But I just want to make that clear. Since, as pointed out by AG Branch at the beginning of our presentation, the nation has been advocating for placement with our Navajo children with their extended family. In that effect, there has been most of the child custody proceeding, 65% of our Navajo children are placed with their extended family, which has been an 11% increase from last year. I will defer to Crescentia if she wants to add anything to that point.
Thank you, LaTanya. We're looking at ICWA preferred placements. We're looking at placement back in the home with the parents, a relative, or an Indian family. When we're referring to non-ICWA preferred placements, that's in a non-relative, non-Native American foster home, in a group home, in a residential treatment facility, or in a juvenile detention center. And so our goal with the program is really to work on ensuring that the state is making efforts to identify a relative and place the children in the least restrictive area or in a least restrictive home. And our hope is that we're making sure that across the board, the state is making efforts to always look at that first placement preference. And throughout the life of the case, there may be new relatives that are identified, or circumstances can change for those who may have stated at the beginning that they weren't able to be placement. And that's really one of our primary goals, is to make sure that the child's connection to the family and the tribe is preserved, and we're always moving toward that.
Thank you, Crescentia. As I noted at the beginning of the presentation, ICWA applies to child custody and proceedings, which includes a foster care placement, termination of parental rights, pre-adoptive placements, along with adoptive placements. And generally those include when it comes from the state, for example, like a dependency issue. There are cases when there are private matters. And what I mean by private matters is when there is a private termination of parental rights to allow, for example, maybe mom is Navajo and the father maybe has been deceased or his rights have been terminated, and they want to allow the stepfather to adopt the child. Those are called private actions, and according to ICWA, those type of actions also are under the umbrella of ICWA, and the nation would also be involved in those particular cases. So it doesn't just involve, it's not just in ICWA just doesn't apply when it involves a dependency issue. It involves in situations that I just noted when there is a private action. To date, the nation has received 32 private actions involving termination of parental rights, private termination of parental rights, adoptions, and guardianships. Of those 22 private petitions, the Navajo Nation ICWA program has assigned the Navajo Nation social workers to be involved in 22 of those private petitions.
And the remaining 11 were not assigned due to either the petition being withdrawn or child or children did not meet eligibility criteria with the Office of Vital Records. This particular effort was a huge one. Prior to 2023, the Navajo ICWA program was not involved or getting involved in these private petitions. And so during our internal reassessment of the program and really working towards strengthening the program, and our involvement in these cases was ensuring that we are involved in places where ICWA does apply. And so this was a coordinated effort by between the Navajo ICWA program and the Department of Justice to ensure that in all of these cases where ICWA applies and it involves a Navajo child, that we are providing advocacy in those areas. The Navajo ICWA program, so a majority of our staff here are trained social workers, and so many of us do not have a background in American Indian law or the law field in general. And so we work very closely with the Department of Justice and also the attorneys that represent us on the state side to ensure that our ICWA social workers are provided training so that we are aware of legal issues that may arise. And so one of the things that we have been really working toward is really identifying what we like to call red flags. If we're noticing that in a court hearing that the judge is not allowing the ICWA social workers to provide recommendations, or if there's attorneys in the courtroom who are opposing the recommendations made by the ICWA social workers, those are times that we will coordinate with Department of Justice to make them aware of the case, and through our legal staffings determine the next steps. And so through these trainings, it's really helpful to hear from the legal perspective on what steps to take, how to address the court, and really making sure that our recommendations are read into the record so that we have a statement by the Navajo Nation indicating why it's important for A, B, and C. Oh, another huge internal assessment that we made under the Division of Social Services and through this administration was going through a rebranding phase. And so our executive director, Mr. Thomas Cody, has taken the lead on really assessing each program and making sure that each program is working toward addressing the needs of our Navajo children and families. And the ICWA program is one of those programs where we are making these changes that we're presenting to you today to really be effective in these cases, and that our response to these cases is timely. And that really means looking and internally on things that we can do to be a little bit more effective, as I mentioned. And so part of this is also looking at increasing our foster and adoptive homes. And so one of the main reasons why we may legally intervene is that the case may have been open for 9+ months, and that we are now have identified a relative who can be placement. In situations like that, the state may argue that this child has been in this placement for an extended period of time, therefore moving the child may be detrimental. And so making sure that we have available foster and adoptive homes early on in the case is really important, and that's an effort that we're working toward as well.
Thank you. In another area that, the nation is working as a team is the nation had previously had an agreement between the ICWA program and Office of Vital Records. And the purpose of that initial agreement was to assign a staff to assist with determining eligibility and enrollment. And that is important because the nation needs to determine whether the child who is subject to the child custody proceeding is deemed as an Indian child, whether that child is eligible or enrolled with the Navajo Nation. And the previous agreement, it was very simple, and one of the areas that it was important to see a need and ensure timeliness was to ensure that we determined whether the child issue was eligible or enrolled. And we need to determine that in a very timely manner to allow the ICWA program to become involved of the child custody proceeding. So because of that, the nation, the Office of Vital Records, along with the ICWA program, amended their agreement. And the agreement does provide for a lot more information, such as what documents need to be provided to the Office of Vital Records in order to determine eligibility and to determine enrollment. We have also included timelines that would require Office of Vital Records to determine eligibility and enrollment. So in working between those two offices and providing those documents and ensuring the Office of Vital Records makes this a priority to assist with our Navajo children, that the Office of Vital Records has been able to determine eligibility and enrollment all the way to 5 days, which has been a huge task because prior to this amendment, some of the determination were taking from 30 days to months. So I do also want to commend the Office of Vital Records for making it a priority to allow the ICWA program to become involved sooner than later, to advocate for our Navajo children and also ensure compliance with ICWA and also the states that have enacted their own state ICWA laws, such as the state of New Mexico. On that note, the state of New Mexico, along with other states, have enacted their own version of ICWA. For example, the state of New Mexico in 2022 has approved their own state ICWA law, which is titled the Indian Family Protection Act. There has been efforts by the other states such as the state of Utah to also enact their own state version of the ICWA. But that did not proceed moving forward. So now we're looking at these state ICWA proposed amendments on a case-by-case basis. But one of the areas that we are working on is there also is a current agreement between the Navajo Nation Division of Social Services and the state agencies that handle child welfare, such as the Department of Child Safety in the state of Arizona, CYFD in the state of New Mexico, and also Department of Child Safety, Family Services in the state of Utah. And those are the state agencies that handle all the child welfare proceedings within those respective states. So the nation entered into agreement in 2019 to allow the nation and the state agencies to further implement ICWA. So, that has been 5 years ago, and there has been a need to amend these agreements to modernize their agreement for various reasons, such as, for example, with the state of New Mexico, we need to amend it to be in line with the New Mexico Indian Family Protection Act. And we also need to amend it based on practical issues to ensure there is a smooth transition and process to allow more collaboration and communication between the nation and those respective state agencies. So the nation is having ongoing communication, specifically with the state of New Mexico, and then also the state of Utah, and we'll be moving forward with amendments within those respective agreements. And those agreements, as I had mentioned, further implement ICWA to allow each government to work cooperatively together for the advocacy of our Navajo children. That has ended our presentation. We are more than welcome to accept questions. Thank you, Brandon and Bernadette, for the comments to AG Branch. As under AG Branch, we are working hand in hand with the Division of Social Services, along with other divisions, to advocate for our Navajo children and our Navajo families. And we are being proactive to ensure that we continue to advocate for ICWA and there's no equal protection challenges moving forward. I do want to thank everyone within DOJ as well as the ICWA program for all their efforts, especially the ICWA social workers. They're on the front line advocating for our Navajo children and our families. I will defer to my colleagues Sage and Crescentia if they want to add anything to end this presentation.
I just want to make a quick comment that from Division of Social Services, we greatly appreciate the collaborative effort in just strengthening ICWA across the board for a Navajo Nation.
Thank you, Crescentia. I appreciate everyone's time and joining us as we discuss Brackeen a year later. As noted earlier, the Brackeen decision was issued on June 15th of 2023, and we are very happy to note that the United States Supreme Court opinion that did not challenge ICWA moving forward. Thank you. Appreciate it. Have a good day.
Thank you.